Good afternoon, ladies and gentlemen. We will be slowly starting the third in a series of 4 webinars organized as a part of the Central and Eastern European and Central Asia Summer Academy, which is organized as part of the Lighthouse Keepers project, which benefits from a grant under Active Citizens Regional Fund from Iceland, Liechtenstein, and Norway through EEA grants. And today's event will focus on holding corporations accountable for human rights abuses. And I do have the honor of introducing Dr. Elena Uvarova, professor at the Yaroslav Mudry National Law University in Kharkiv. Elena also has started a number of years ago an international lab on business and human rights at this university, which basically helped to educate a number of representatives, both from administration, but also companies on business and human rights issues. So it was like a spring that helped to water a number of groups and representatives of different sectors. And today, Elena will have the task and to lead you through the discussion with the invited experts. I'll leave it to Elena to introduce the fantastic experts of today. And she'll lead the discussion on a very important issue, namely how corporations actually are held accountable for the abuses that they commit. Because we do talk a lot currently at the EU level, but also in other countries about what companies need to do to prevent human rights from happening. But unfortunately, the abuses do take place, and we need to also talk about what to do to make sure that justice takes place and that access to remedy does not remain just an empty formulation. So Elena, thank you very much for agreeing to moderate today's discussion, and let me give you the floor. Thank you very much.
Thank you very much, Beata. And actually, it's a great pleasure and great honor to moderate this excellent discussion with amazing speakers. And yeah, our webinar today will focus on judicial and non-judicial mechanisms and practices of the operation to establish liability of corporations. And actually, a special emphasis will be placed on barriers to access to justice in different countries in the region in cases of business-related human rights violations. We will also discuss when a parent company can be held liable under the law of civil remedies and many other interesting issues. And of course, it's especially interesting for us to pay attention to the challenges which our region has when we are talking about access to justice in such cases. And as Beata said, it's a very important part of business and human rights concept to hold corporations accountable. And actually, to my mind, the main driver for the development of the business and human rights concept was and still is the desire to hold corporation accountable. And this is actually the build of this concept was violations committed by corporations and actually the challenges which courts and other actors which should provide protection from such violations, challenges which they have in such cases. And there is a constant dynamic and tension in law in general caused by the fact that our expectations based on the principles of equality, freedom, justice don't match the existing experience. And I think that this actually when we have such situation, when our expectations based on such values of law match with this existing experience, actually the first actors who who meet with this problem is courts and other actors who provide non-judicial remedies to protect. And that's why our conversation today is so important. And I see actually in this conversation, as I said, the key drivers of future development of business and human rights concept, how we can find ways to make the remedies to protect victims of business-related violations more effective and more transparent and more accessible. So we will have 4 speakers today, 4 excellent speakers. Dr. Ekaterina Aristova, she is a Leverhulme Early Career Fellow at the Bonavera Institute of Human Rights in Oxford, and her research focuses on the access to justice for victims of business-related human rights violations. And she has published a lot of interesting papers on the viability of strategic human rights accountability. And Ekaterina actually leads a lot of very interesting initiatives related to access to remedies in business-related human rights violations. We also have today with us Bartosz Kwiatkowski, director of foundation, Frank Bolt Foundation, and Bartosz is a lawyer with more than 12 years of professional experience, vice president of the Polish Institute of Human Rights and Business, and a member of the program board of the Development Yes Open Pit Mines No Foundation. He is author of different guidelines, in particular related to OECD National Contact Point procedure, and his expertise is really unique on this issue. Anna Dangova, BHR lawyer, she represents law firm Inter Partes Skopje, North Macedonia, and we cooperate with Anna for a long time, and Anna can share with us her experience, practical experience, how to work on business and human rights cases in practice. She is a lawyer and she is a co-founder of Inter Partes, and this firm is the leading law firm in North Macedonia that offers a package of legal services to clients to enable them to work in line with the UN guiding principles. And also today with us is Dr. Bogdan Karnau, Associate Professor, Yaroslav Mudry, National Law University, Kharkiv, Ukraine, and my personal friend, and we realized a lot of initiatives with Bogdan in Ukraine related to business and human rights issues, and I am happy to see him today with us. So we would like to start our discussion, and I would like to start with Dr. Ekaterina Aristova. And Ekaterina, please, what is key, actually key challenges and key developments related to strategic litigation on business and human rights cases that you can share with us?
Thank you very much, Lena. I hope you can see my screen now. So that's okay. Excellent. Yeah. Excellent. Well, thank you very much, Lena and Beata, for the kind invitation for this excellent series. I'm really pleased to be here today. I'm looking forward to our conversation. I'm looking forward to learning from the speakers as well. So I'll talk, as you suggested, a little bit about at the start of our discussion about holding multinational enterprises accountable in general, about impact of strategic litigation. And just to give a bit of a background to the audience, we've seen the increase in the number of corporations operating across territorial borders in the 20th century. And the growth of these multinational enterprises has been also accompanied by the rise of awareness about the negative impacts of their operations. And due to the existing governance gaps in the international and national legislations, victims of business-related human rights abuses and their lawyers started to use strategic litigation as a tool to foster corporate accountability. We've seen that this business and human rights litigation often occurs in transnational contexts when claimants from the host state, usually a developing state in the global south, are bringing claims against a parent company which is located in the home state where the headquarters are based. And we've seen those cases in common law and civil law systems. We've seen civil and criminal cases, and I will focus today on the civil litigation in particular. I will share findings from the project on civil liability for human rights violations led by the Bonavera Institute of Human Rights. It was funded by Oak Foundation, and it took place in 2019-2022. We actually finished just last year, so I'm very pleased to share the outcomes. So the primary purpose of the project was to determine whether and when the law of civil remedies provides a real opportunity to hold state and non-state actors accountable for their involvement in three specified types of human rights violation: assault or unlawful arrest and detention of persons, environmental harm, and third, harmful or unfair labor conditions. The scope of the project was quite broad, but one of the research questions was explicitly the limits of parent company liability and supply chain liability under the law of civil remedies. The project involved two components. The first component was a bit of more of a scholarly analysis of the challenges and opportunities for using civil claims as a mechanism for human rights accountability. And this outcome was published as a book by Hart Publishing, Civil Remedies and Human Rights in Flux. It covered 16 jurisdictions. I put it on the slide, you can see them, and of particular interest for today's discussion is Ukraine. And of course, I can't avoid saying that the author of the Ukrainian chapter was Bogdan Karnaukh, and he did an excellent job of outlining the key challenges and opportunities for using civil law in Ukraine. So please consider reading this chapter. And then the second outcome, the second component, was publication last month of the handbook for practitioners. It covered 19 jurisdictions, including Russia and Ukraine, and Alena and Bogdan cooperated together in producing the Ukrainian chapter. And I must say that the final draft was finalized this spring in unprecedented conditions. And Lena and Bogdan did such an excellent job. So I just want to say how much I admire your strength and your dedication and excellent effort to contribute to this project. Thank you very much for this. So the handbook in particular is a free online resource, which is available to be downloaded in PDF format by anyone. And after my presentation, I'll share the links in the chat. So I want to share with you a few findings, and I will focus particularly about parent company liability, but the scope of the project is much broader, but I'll just cover this one particular issue today. So what we examined is how the law of civil remedies operates in relation to complex corporate structures. And we asked a particular question, whether a parent company liability can be held liable in your jurisdiction under the law of civil remedies if the harm was caused by the subsidiary or by the supplier. What are the conditions for that? And the basic finding, which is, I guess, undisputed and unsurprising that arose, is that all contributors said that, yes, separate legal personality and limited liability principles are well recognized as a foundation of corporate law in all focused jurisdictions. And in most of the jurisdictions, the problem of parent company liability is dealt as a matter of corporate law, but legislation on corporate groups exists in a very exceptional and fragmented manner. And if we talk about the exceptions, they're usually, these exceptions are related to bankruptcy context or to anti-fraud competition, but rarely go any further. Now, we do see an apparent trend in the Western jurisdictions towards civil claims alleging direct liability of parent companies for harm that occurs through their overseas operations. For example, I put in the brackets Australia, Canada, England, France, Netherlands, and US. And particularly prominent this trend was in the common law jurisdictions where litigators have creatively relied on the duty of care in negligence. And civil claims usually arise from domestic sources of law, so they're not actually explicitly litigated in human rights terms, and rarely a violation of international law may be an element of civil cause of action. So I put as an example Alien Tort Statute claims in the US, and I know that Bogdan will later on talk a little bit more about it. But there are a few other examples. But what I want to stress at this point is that we are still talking, still speaking on a comparative basis about a very small number of jurisdictions that have seen these direct liability cases. If you look at the international context, if you look at worldwide, still the main paradigm is this separate legal personality. And the most we go is to discuss the pissing of the corporate whale, but still sort of the main issue is limited liability principles, and the overall success, I would say, on a world basis is quite modest in advancing parent company liability. Now, the instances of supply chain liability in the focus jurisdictions remain rare, and I'd say that even less prominent. I again put just a few examples. Kick case in Germany that arose out of the fire in Pakistan. A lot of people were killed or injured, and the claimants brought a case in Germany against a big supermarket chain that was the main customer of this factory where the clothes were produced, but unfortunately this case was dismissed. There are some interesting cases going on in the UK at the moment, but they're still at the very rare stage, so it's hard to say whether we are seeing anything as a trend. Also, what we identified is that another problem for the law of civil remedies is this explicit lack of rules for complicit or accessory conduct. Again, I know that Bogdan will be talking a little bit about this corporate complicity. It's often that corporations are not direct perpetrators, but they contribute in one way or another to the violations which are committed by state actors, police or paramilitary forces. For example, if they're killings or shootings or tortures, which is done by the state actors, the corporation can supply equipment, it can provide money, it can buy weapons. And this link of contribution is rarely recognized by the civil law. There are some instances of this in US and the UK, but it's usually quite difficult to establish the test to hold corporation accountable. Several reports, and I think Ukraine was one of them, they indicated the concept of complicity exists in criminal law, but not in a civil law. And we've seen, for example, in France, few interesting criminal cases, including Lafarge case. And so sort of as a overall conclusion, I want to say that the discussion of the direct liability of the parent companies is very much dominated by the jurisprudence from the Western states. And the debate is very much dominated by the Western states. We're now talking a lot about mandatory human rights due diligence with the possibility of civil enforcement for non-compliance. But again, it's a very positive step, in my opinion, but it won't change the worldwide picture of how legislation is drafted in the global south or in developing world, or it won't address really barriers to justice in the host states where violations are usually occurred. So just as a conclusion, so is litigation a magic pill? What sort of, is it a panacea? What sort of impact it's having? So as a conclusion, we make that in many jurisdictions, indeed, the law of civil remedies is used to close a gap and is evolves in response to different needs and different challenges. And it's likely to continue to develop in this field. So for example, we're likely to see more climate change litigation against corporations because this is a quite relevant topic, but it is also evident that civil claims are not always a perfect solution, and they are complementary. Now, we don't want to say, and I don't want to say that there is no value in using strategic litigation, and I put some advantages on the slide and some limitations. So it's not what I'm trying to say, it's just that it's one of the elements of the global regulatory landscape, and should be approached in this way. There are a few advantages of using tort claims, civil claims, and I think, again, Bogdan in the Ukrainian chapter in particular noted about flexibility of the law of civil remedies, because it provides the basic formula. If there is a harm, and if there is a link between the perpetrator, the acts of the perpetrator and this harm, then the perpetrator should compensate the damages. So this formula, very easy one, can be used in different contexts. And civil remedies can be potentially used in the extraterritorial context. They also do have a lot of indirect impacts about raising awareness, etc. But also there are inherent limitations. And again, I put a few of them in the on my slide, but one particular notable are various procedural barriers to access to remedy. And I think Anna will be talking about this in the Macedonian context. So we'll leave it here, and I'm happy to elaborate any of those issues in the Q&A session. Thank you very much.
Thank you very much. Actually, I think that Western world leads business and human rights topic in general, and actually it's one of the challenge for business and human rights concept. And yeah, we need to solve this problem, I would say. Bogdan, I would like to give the floor to you, and actually Katerina already announced a lot from your presentation. So yeah, please share with us your thoughts about civil remedies to protect human rights from business-related violations. And one question personally from me as a scholar from Eastern Europe, actually, why this topic is interesting for you and what challenges do you see in this topic?
Okay, thank you, Elena. Thank you for this question. I'm very glad you asked. Thank you, Beata, for inviting me. Thank you for having me here. And thank you, Ekaterina, for mentioning on so many occasions that I have participated in the project. That was a great honor for me to be one of the co-authors of the book and of the guidelines for practitioners. So, corporations as accomplices of gross human rights violations. Olena, you've asked why it is important for me, and I am now in Ukraine, in Kyiv. I hope you've heard that yesterday we had a massive attacks on our infrastructure. So most of the Ukrainian cities are now without electricity, running water or heating. So we are on the edge of a humanitarian catastrophe, in fact. So why am I speaking about corporations as accomplices to human rights violations? Maybe some of you know that recently, or maybe you don't, recently, Ukrainian Supreme Court held a decision where he said that Russian Federation shall not enjoy immunity with regard to tort claims which are based on the damage caused by the aggressive war. So here is the number of this case, and you can briefly take a look on the facts. I will not go to the facts just to save the time, but Supreme Court said that from now on, everyone who suffered from the war is allowed to bring a lawsuit against Russian Federation in Ukrainian courts. And our Supreme Court based his decision on two conventions, on European Convention on State Immunity and on the UN Convention on Jurisdictional Immunities of States and Their Property. And the decision was based on the concept which is known as territorial tort exception, which says that immunity does not apply in a tort case as long as the harmful act or omission occurred in the territory of the state of the court and the tortfeasor was present there while committing the harmful act or omission. As you can imagine, all those requirements are met with regard to war. So the court said that you can sue Russia in Ukrainian court, which is contrary to general principles of international law. So, but the point is, I wrote an article on this particular issue. So if you are interested, I am advertising the article to you. You will be able to read it into languages, both Ukrainian and English. So for further details, please go by this link. But I want to talk here about the responsibility of corporations. And what is interesting is that after the Supreme Court opened the way for the claimants to sue Russian federations, they started to bring actions. And in some of the cases, they sue not just the Russian Federation, but also some Russian companies, in particular banks. So in particular, there are a few cases where the co-defendants with Russia also joint stock companies Sberbank, that's a bank which is controlled by Russia, and also the other bank, which is joint stock commercial, industrial, and investment bank. And it revealed a very important problem, that in those lawsuits, there is no justification why we want to hold those companies liable. And it spotlighted a very systematic problem that in Ukraine, we do not have elaborate theory of secondary liability, of liability for aiding and abetting, of liability complicity in tort. We do have this concept in criminal law, but we do not have those concepts almost at all in our tort law. Another interesting story which is happening right now is that in United Kingdom, one of the companies, McHugh Jury and Partners, announced that they are preparing a lawsuit against Wagner Group. That is a private military company that is employed by Russia to wage the war against Ukraine, and they are committing one of the most egregious crimes during this war, and they are infamous for absolutely disregarding any rule of law at all. So they also are accomplices to war crimes, but we do not have in Ukraine theory how to explain why they should be responsible. Another interesting fact is that you may also heard that Russia is using Iranian drones to attack Ukrainian infrastructure. And recently, Iran declared that those drones were supplied before the war started. However, there are some investigations that show that that is not the case, and the production date on those drones show that they were produced in February 2022. So all these interesting developments, they show that we need a decent, a sound theory of secondary liability. And what I was thinking is that where do we have this elaborate theory? We can find it in alien tort statute litigation. And this could serve as a source of inspiration for Ukrainian cases. And I found one very interesting article by Elizabeth Beavers, which is called War Crimes Incorporated, the ATS case against US weapons industry for aiding and abetting atrocities in Yemen. And the author in this paper explains and shows that American companies that produce bombs and explosives and missiles can be held responsible for the atrocities committed in Yemen as the accomplices to those atrocities. And so I thought, so why wouldn't we use those developments and those decisions that were developed within ATS litigation in Ukrainian case? So I will not, of course, go through all the interesting and tumultuous history of ATS litigation. I'm pretty sure that here we have the audience which is familiar with business and human rights. realm. And of course, Alien Tort Statute is one of the most famous documents in this realm. So I will not go through the history of that document. So I will just go straight to the takeaways which we can take from ATS litigation for Ukrainian situation. So I guess that findings by American courts could be very useful for Ukrainian case. So in Doe versus Unicol Corp, the court defined what is the aiding and abetting by saying that it is a knowing practical assistance or encouragement that has a substantial effect on the perpetration of crime. So from this perspective, I'm pretty sure that Iranian producer of drones could be held liable as the accomplice of atrocities committed in Ukraine. For sure, there could be no doubts that Wagner Group could be held responsible as the accomplice, and not just for the aiding and abetting, but even, I guess, as the principal offender and or as an accomplice. So I guess that from this ATS litigation, we can take a few lessons. First lesson is that tort law can utilize criminal law doctrines on secondary liability. So tort law should not hesitate to borrow from criminal law, because American courts in ATS litigation extensively used the case law of international criminal tribunals, in particular for former Yugoslavia and Rwanda. And we have a very interesting interplay between criminal law and civil law. So we should borrow from criminal law and build our tort law doctrine of secondary liability on the decisions that were developed in criminal law. Second, the scope of secondary liability in tort law shall be no less than in its criminal counterpart. In other words, the scope of secondary liability in tort law should be the same in scope or even broader than in criminal law. Third, corporations may be held responsible for aiding and abetting. So, and that is one of the aspects in which civil liability should be broader than criminal one, because there is much debate whether corporations could be held responsible in criminal law, but I guess we do not have doubts that they could be responsible in torts. And once again, the last one, in ATS litigation, we saw that there is a very sharp debate over the mens rea standard. Should it be knowledge standard or should it be purpose standard? And we have to be prepared for the similar debate with regard to civil liability. Thank you for attention. Very glad to be here. And if I am here, if electricity allows me, I will be glad to answer the questions in the Q&A session. Thank you.
Thank you very much, Bogdan. It's a really very inspiring presentation. I just have one question to understand correctly that you said. Do I understand correctly that Ukrainian courts will have jurisdiction to consider these cases?
Yes. That's the last position of the Supreme Court. We have a few difficult questions. So Supreme Court said that Ukrainian courts can hear cases against Russia. So because Russia does not have immunity because of the territorial exception. But we have two problems here. First, if the decision is delivered, how to enforce it. But even earlier, when the case is heard, how to inform Russia and allow Russia its hour in court and to present its position, because we have to follow the principle of equality of arms, and we have to follow the procedure, and the defendant has to be able to present his case. And as you know, all of the diplomatic connections between two countries are now disrupted. We cannot even send regular letters to Russia. So that is also a problem. But in general, Supreme Court said, yes, you can sue Russia in Ukrainian court.
Thank you very much. It's extremely interesting. Thank you. And yeah, I would like to ask Anna, what examples, if any, of strategic litigation do you have in North Macedonia, and actually in more general, what is your experience to work on cases which related to business to business abuses of human rights?
Yeah, thank you very much. Thank you for the nice introduction. It's really a pleasure to be here and sit in this exceptional lineup of panelists. I would like to share with you a case that a recent case that I had the privilege to work on, and I will give you just a little bit of background. It's an air polluted related case, and as you may know, we have really a lot of problems with air pollution in the past, but also now. So I wanted to give you just some facts about air pollution, then speak about the case and the outcome of the case. As you can see here on the right, our main focus were PM subsidies. And these are the limit values that also our country has accepted in terms of PM10 and PM2.5. And these are air quality standards also in accordance with the European Union regulation. So the short facts are on the right. There are some pictures, and these are screenshots of the air that I took. And also, as you can see, these are the numbers of PM10 and PM2.5. So you can see that even now, 10 days before, actually, they were higher than the agreed values. So the daily limit value of PM10 is constantly exceeding 120 to 180 days per year, which is way above the accepted norm of 35 days per year. And this has been happening from 2008 onwards. The annual concentration exceeds the European Union limit value in nearly all Macedonian cities. There is only one city, it's a small city in the mountains that is kind of in line with the European Union regulation. The life expectancy of 30-year-old citizens of the capital of Skopje is 0.8 years shorter due to exposure of PM 2.5, meaning that we will live shorter in general due to the air pollution. And the industry, together with the households, has been identified as having the biggest impact on air quality in the country. When I was preparing the presentation, I saw that in November in 2019, Skopje was the 4th most polluted town in the world. As you can see on the left, it's positioned just below China. And on the right, I saw that this year, on the same date, a small town called Negotino has 350 PM10 subsidies in the air during the night. I'm saying this just to demonstrate that the situation hasn't changed a lot from 2019. So we have brought a case. I was acting as a lawyer of an NGO called Macedonian Young Lawyers Association. And a colleague of mine was representing an individual. He's 40 years old with a tumor. He was cured. The doctor said that most probably the tumor is due to air pollution. As you can see, the defendants were 3 parties: the government of North Macedonia, the ministry, and the municipality of Skopje. So we had a very ambitious task. And the lawsuit was launched in 2019 before the Skopje Basic Court. We really had a lot of discussion whether to submit the court in front of the civil court or in front of the administrative court, but kind of bearing in mind the procedures, we decided that the Basic Court has jurisdiction to decide on the accountability of state actors for air polluted related human rights violations. So the claims, we had two claims. We had one declaratory claim, and with the first claim, we wanted the state to find that the plaintiffs have violated a couple of human rights: right to health environment, right to privacy of personal and family life, and the inviolability of the home, without seeking compensation. So really, we didn't want any money. We just wanted a declaratory claim. And as Ekaterina said, it's true that the civil law is kind of backwards looking, but we've also inserted one condemnatory claim. We really wanted that they take actions. So this was very progressive. We knew that we will fail at least on this one, but we wanted to have it to be on a safe side, because in terms of money, it was not costly for the NGO to pay the costs, even if this was refuted. So what we asked is actually a couple of things. It's a very long condemnatory claim. I'm just outlining some of the issues here. Basically, we want the court to order the state to harmonize national legislation with European Union air quality directives, to establish an integrated system that will provide for a comprehensive exchange of data, etc. A couple of these measures were directed towards the business community. So what was our argumentation? Our argumentation was that, of course, the state has failed to fulfill with its obligation to maintain the level values of PM concentrations as agreed. We really positioned this case within the international human rights framework. We have also relied on the Aarhus Convention and the findings of the Compliance Committee, the Jurisprudence of the European Court of Human Rights, report of UN human rights bodies. We have also invoked the European Court of the European Union, even though we are still not members of the European Union. We have provided lots of evidences, as we had problems with the hiring an expert. There was a lack of cooperation from experts, so we needed to rely on state reports. Then there's some information that we find that there was a lack of environmental inspection of certain stationary sources, absence of a catastrophe of pollutants, and this was backed up by responses from state institutions. Defendants, of course, they raised a couple of arguments. They were claiming that the NGO lacks active standing, lack of competence ratione materia. This was the biggest argument that they actually invoked, that the civil court doesn't have any jurisdiction on the case. This is a pure case where we actually want the court to state some facts, which is not allowed according to our law. And actually, they have produced evidence from 2018 onwards that they actually have done a lot to combat the air pollution. So the decision, in a very, very fast procedure, very fast, the case was dismissed. The court found that it is not competent to impose measures on the executive branch as required of the second claim. And regarding your first claim, is stated that actually we want the court to find facts and not violations of human rights. So we kind of twisted a little bit the argumentation in order to dismiss the case. And the court stated that we could have directed the lawsuit directly against the economic operators, or that we can initiate administrative or constitutional procedure, but it was not the point. We really wanted to base the case within the human rights language. And we decided not to go against the economic operators because it would have been very difficult to prove the causality link for any damages. We were actually, as lawyers, struck by the way the court interpreted international law. For example, it found that the Aarhus Convention is not applicable here. Article 9 on access to justice that the court should not rely on the jurisprudence of the Court of the European Union, and actually stated that the jurisprudence of the European Court of Human Rights is irrelevant for North Macedonia unless it is a party that is directly linked to the case. We have, of course, filed an appeal to the Skopje Appeal Court. We have challenged the judicial interpretation of the National International Court law, while as the defendants gave a short response proposing that the court rejects the appeal as unfounded. Our appeal court, on the, as you can see on the picture, dismissed the appeals. However, it found that this case raises so important issues that it's important for unification of the implementation of the law and unification of judicial practice, and asked exceptionally the Supreme Court to rule on these issues, but without providing any other national jurisprudence, because there is none, to where the Supreme Court can actually give a final ruling whether the Skopje court is obliged to actually decide on the merits of the case or not. So the Supreme Court of North Macedonia again rejected our revision because it stated that the appeal court failed to provide any case law. And again, this is on a very, very procedural level. If you look at the way these courts have looked at the case, it stayed on a procedural level, so we don't have any decision on the merits. So I was just kind of outline some implications of this decision. First, at the present, it is evident the Macedonian civil courts cannot adjudicate whether state bodies, but also even business and entities, have violated their respective obligations, which has in turn led to air pollution-related human rights violations. They really don't see them as active courts. At the moment, there is no room for us to go to seek justice. It also exemplifies how international law is interpreted by national courts. It is not only my opinion, but there is a group of lawyers who look at the case and say that this is very shocking, the way that they approach international human rights law. It also conveys that the judiciary is not mandated to compel the executive to act, meaning that we really wanted to try that the judiciary orders the executive to act. There are a couple of developments in this field. For example, in Sofia, there is a case where the Sofia court has issued order actually on the municipality of Sofia to undertake concrete measures. So we haven't asked something unfounded. It's just that they found that at the moment the courts are not ready to issue such a decision. And because of procedural barriers, victims have been prevented to publicly present relevant evidence on human rights violation. I think we had maybe 4 folders, very big folders with documents and evidence. It's a lot of things on a video, a lot of witnesses and experts that we wanted to come and testify, but of course we were prevented because of this interpretation of the law. And I think that this case really represents a pragmatic example of the necessity for adopting a regulatory framework that will accommodate the new developments and accountability of state and non-state actors in cases involving human rights violations. It will be super difficult if we proceed with the existing legislation, if we want to seek any accountability in these issues. So I think I don't say anything new that we need to change the laws and that we need national action plans that are substantive, because if we operate within this existing national framework, I would say that not that I'm pessimistic, but I'm realistic. I don't think that we will go further. Thank you very much for listening to me.
Thank you very much. So do you believe that raise awareness and capacity buildings of executive power of the state is much more easier than raise awareness and capacity building of judiciary?
I think to start with, I think we start with, yeah, I think I'm sure that in every country there is an academy for judges and prosecutors, and they have a curriculum. And I've looked a couple of times at this curriculum. It's an old one. International law is really at the basics. We don't have any component on environmental law. The Arcus Convention is something so new. If you speak about findings of compliance committee, they look at you like, what are you talking about? So, and that's fine. I mean, I don't want to blame judges. It's just that we need to make really structural changes in the way that judges think. And in order to do that, we need to give them trainings. And they follow. I mean, it's not that they don't follow. If you insert this in the curriculum, that they need to go to first basic trainings, then advanced trainings, etc. And as for the executive, I mean, it is developing a national action plan. It is in the strategy of the government, and there is a budget for that. And there are 3 bodies that apparently will be in charge of leading the process. But I think there's just not, this is not a top priority. The time allocated was between 2019 and 2022, and we are at the end of 2022. I think nothing happened. There is a steering committee on business and human rights. I'm part of it. It's a really good group of people that want to make change, and we do push for how to say, we give sign to the government that they need to do something by providing with data, but providing with guidance and indicating that we are far away from the European Union discussion. But I guess another problem is that there is no leading ministry, one ministry that will really say, okay, I'm going to be in charge and I'm going to work on this, because this topic has been shifting throughout a couple of ministries, and when ministers are changing, they don't want to give this topic to another one, and we lose time. So I think it's not only legal, but it's political. It's political.
Yeah, I agree. Thank you very much. And yes, the question is, do we have any alternative to judicial remedies, and can OECD national contact points could be considered as such alternative or not? Actually, can they provide some additional opportunities to make right holders stronger when they are trying to find justice in cases of business-related violations? So Bartosz, please, the floor is yours. Bartosz?
Bartosz, I think you are muted.
Yeah. I was muted.
Okay,
Sorry. I'm always muted in 3 places. So yeah, it takes time. Sorry for that. I hope that you can see my presentation, the first slide of it.
Yes.
Just before I start, I would like just to refer very briefly to what Anna just presented seconds ago, because we succeeded in similar case in Poland last December. We successfully won against the state regarding air quality in Rybnik, and the state was obliged to pay damages to our client, the citizens of Rybnik. So that's good. But the main difference, of course, is that Poland is still member of the European Union, and that's the reason it was successful. But going to the OECD and the guidelines and the national contact points, is it possible to use such non-judicial mechanisms successfully? I will try to answer this question. And first of all, very briefly, background. As you can see, a long time ago in a galaxy far away, in 1976, the guidelines for multinational enterprises were introduced, and that's very important date, and that's very important to notice that it is 46 years ago. So almost 50 years ago, the guidelines were introduced. And it's very important when we are talking with companies, it's very important when we are talking with governments, that what's happening right now, especially in the European Union, in terms of regulation around non-financial reporting, due diligence, and all this stuff connected with ESG, it's not really a revolution. It's only evolution, and some standards, some benchmarks we have already in place for last 50 years right now are coming to binding regulations. So that's very important to underline that when somebody is trying to defend his or hers business, that come on, it cannot be done so fast manner. I don't have money for that. I cannot comply with these regulations because I'm not ready for it. You had enough time, in fact. So that's the first point. And the second one, to enforce this OECD guidelines, 51 OECD NCPs right now are working, and they are, despite for promoting, they're also responsible for handling cases which are called specific instances in the guidelines. Today I would like to say a few words about the effectiveness of this procedure, which we also tried to use a few times in Poland with different results. However, I won't be talking about Polish cases. And the thesis I will present to you in the beginning, and the answer to this question is the guidelines and the NCP proceeding is effective and is it successful? I will answer no, it's not. However, I'm a lawyer, so there's always but, there's always it depends, and that probably will be the case of this guidelines and these proceedings, and you will see in the end of my presentation why I see many hopes and some hope for making a change here. First case I would like to show you briefly is the case of organizers of Formula One Grand Prix in Bahrain. There was a case a few years ago connected with organization of race of Formula One in Bahrain. It was connected with human rights, of course, with employees' rights, also the presentation of good image of a country which is renowned by unfortunately breaching of human rights. This case ended with some kind of agreement between the NGO who informed NCP of the case and between the companies behind the Formula One. And the most important thing underlined in this case was lack of enough or even any human rights due diligence. And if you see the title of this slide, does it ring a bell? For you, probably all of you noticed that right now we've got a very similar situation. And of course, many of us are talking about that, even some soccer players or football players are talking about that and so on. However, the tournament in Qatar is ongoing. The human rights are breached there. So we haven't learned, in fact, anything from the case of Bahrain and Formula One races. So that's the first problem that we can see here. That this voluntary or alternative form of making companies responsible for their actions, it's not working. The second problem we can see in OECD guidelines and in OECD NCP's proceedings or specific instances is connected with voluntariness. I mean that companies are not obliged to engage in the proceedings. There is one very important case of Shell or company who used to or is still exploring oil in Nigeria, and a few NGOs, environmental NGOs, tried to start the specific instance before Dutch probably, or British, I don't remember right now, NCP. The problem was that they at the same time tried to campaign around the case. And that's one of the rules of the NCP proceedings, that you shouldn't do this. It's possible to inform about the results of the case afterwards, but you shouldn't inform about them in the beginning, even before the initial statement of the NCP is issued. What Shell did in this situation, Shell said that, come on guys, if you are going to make a big campaign around this case, we are not going to talk with you in front of the NCP. So that the result of this case was in fact nothing, because NGOs replied that, sorry, but that's our main method of working. It's some kind of advocacy, some kind of campaigning, so we have to do it. So sorry, but this NCP proceeding cannot be used in this case. And saying that, I asked at the fourth point the question: do consumer boycotts work? Because what we have right in such situation when a company refuses to enter this special proceeding is, maybe we can say that this company is bad and you shouldn't buy their products. But unfortunately, we talked quite a lot today about the Russian aggression right now in Ukraine, and we know how many companies behaved, and what are the results of our consumer decisions. Even here in Poland, we have such surveys made that some companies who still, or maybe just some time ago, still made businesses in Russia, remuneration or turnover was bigger than before the war, unfortunately. But as I said, there's always but. So we've got a good example of good case. We've got example of the case which was connected with extraction of gold in Brazil, and there was a case brought by local people, as far as I remember, and it was connected with potential negative impact of this extraction on households and on the local community. What's very important, during this case, there was no link proved between the operation of the company and the damages people had at their houses. However, even though the company declared that they are going to support local citizens and they are going to pay for the problems they have. So starting this proceeding have had a very positive effect on company itself, and also in solving the issues of what's very important also right now is that those guidelines, these guidelines, which are only recommendations, we are not binding, and everybody is underlining that always when presenting the guidelines, they are starting to be recognized by courts as the unwritten standard of care, and they are starting to be mentioned in different kinds of rulings in different kinds of cases. Right now you can see the climate case done by the Dutch court against, again, Shell. And this court recognized the UNGP guidelines and also the OECD guidelines for multinational enterprises as this unwritten standard of care, and use it to rule against Shell. So that's a big change, and this change started to be visible also on the level of European Union regulations, because as you can see on the first dot, you've got a quote from the guidelines. So it's just recommendation, non-binding principles and standards, and so on and so on. But if you look at the text of CSRD, even European standards on sustainability reporting, if you look at SFDR, if you look at the draft of CSDDD, if you look at social taxonomy draft, in all of these documents, OECD guidelines are mentioned. They are mentioned mostly in recitals of these regulations, but in some cases even in actual provisions. So this led to the situation when non-binding principles starting to be binding provisions of European law, and it started to the new obligation, in fact, is created for companies to use guidelines as one of the standards that they are obliged to, not only voluntarily. What's very important, and I'm asking question here: does CSDDD matters? I mean, is it really crucial for making due diligence, human rights due diligence obligation valid for companies? Do we need CSDDD? Do we need this directive on due diligence? And in fact, I would say no. It's not the sine qua non condition, because already these due diligence issues are mentioned in different in other directives and in other regulations, which directly mentioned due diligence and directly mention OECD guidelines. So it's possible to say that companies, even without CSDDD obligations, have to use this risk management process created by UN and OECD. And what's even more important, not only big corporations, which are directly covered by these regulations, should use these processes, but also small and medium enterprises should do this, because if we are looking at the whole value chain of those companies, if we look at how due diligence is working and how it's described by the guidelines, it is that's the rule, that you have to do it in a whole value chain. So you also are covering small and medium enterprises who have to prove that they are using HRDD processes. And last but not least, when talking about these EU regulations, we've got very important regulation, which is aimed to change the picture of European Union economy. So EU green taxonomy, which is aimed to channel private investments into sustainable activities, address concerns about greenwashing. That's one of the aims of this regulation. And this regulation touches, of course, mostly environmental issues. But if you look at letter C mentioned here in Article 3 of taxonomy, you will see that this activity, which is recognized as environmentally sustainable, has to be in compliance with the minimum safeguards. What does it mean, minimum safeguards? Minimum safeguards means, among others, the OECD guidelines for multinational enterprises, and that's the exact provision of the regulation. So it's not only recital, it's the exact wording of the provision. So the company have to prove in the report that they are using OECD guidelines for multinational enterprises, and without proving that, they cannot be a part of this green transformation of EU economy, and they cannot take money from green funding. Just last month, in October 2022, a platform on sustainable finance, so the body which advises the European Commission, issued the report, the final report on minimum safeguards, describing how it should be checked if the company is breaching or not breaching minimum safeguards, and if their products and operations can be treated as environmentally sustainable. And what they underlined is that if you are not established an adequate human rights due diligence process, then you are breaching the taxonomy. And if there is a case in front or before the national contact point, and you are not entering the case, as Shell did in case of extracting oil in Nigeria, then you are breaching the taxonomy. And if the NCP recognizes that you breach the guidelines itself, you're also breaching the taxonomy. So the role of the NCPs, it's much more, it's going to be much more significant than it is right now. So that's very, very important, that the significance and legal recognition of the guidelines and the NCPs itself, it's rising. What we need here, however, is all cooperation of notifiers, cooperation of multinational enterprises, and last but not least, of course, NCPs, who have to be more decisive and firm, because right now what we very often see in these NCP cases is that NCP are not making final decisions if the behavior of the company is breaching or not the guidelines. And last but not least, you see the consequences of violations. So to date, we've got primary image consequences. However, after all of these regulations I mentioned around ESG regulations and also taxonomy come into force, then we've got the potential real financial impact. So these non-binding regulations, in fact, start to be binding law. So that's a big change. And that's all from me.
Thank you very much. It's very, very interesting, and actually it's a very good link to my next question to all our speakers. Actually, how should corporate accountability look like in 2030? What do you think? Maybe Bartosz.
What I can say, it would be a quote of a very famous person. I would say that I have a dream, and this dream is connected with that the guidelines will be binding regulation. In fact, that it will change. That we are not talking for next 50 years. That we've got some guidelines, that we've got some standards, and we are promoting that, and we're talking that human rights are important and companies should also obey them. But it will be reality. What we had before in this area of ESG and non-financial reporting, unfortunately, it wasn't working at all. Right now, we are reforming the whole system, and hopefully it will be better. So what I hope that in 2030, lesson will be learned that these regulations really make difference, and that European, but not only, because those regulations also touches businesses around the world, that those companies will be more responsible. They will recognize the problems we really have here, the crises that are going, and that they will take responsibility for their actions.
Thank you very much, Anna. What are your expectations about next years?
2030 is really far away. I think that there will be a lot of regulation and legislation to hold companies accountable. However, I'm a little bit pessimistic, because I think that they will find a way to sneak out if they want. And there will be a group of companies that will try really to be a leader in this field, especially as there's such a strong impetus now on criminal change related litigation. So I think here they will be more scared, because these are clear rules and there are clear targets. And now, especially after COP27, I think that it goes into the direction really not only loss and damages for the by the states towards other states, but also there will be compensation that need to be paid by companies to individuals. So I think it will be just a diverse picture as it is now.
Yeah, it's already something. Yeah. Okay, thank you. Ekaterina, please, what do you think?
I very much agree with Bartosz and Anna, and I do hope that we'll see some binding measures, but I also hope that we will have some instruments and debate that tackle underlying inequality and then
моменты в законодательстве
and victims, but also between home states, host states, between different, because corporate power is out of regulatory control, and we see erosion of state sovereignty. We see this massive inequality and difference in resources that corporations have, but also right holders, let's say indigenous peoples, for example, women. We talk about children as well, future generations, etc. So I think there is. I hope that there will be more thinking about these issues, but also more about purpose and future corporations. Like, you know, what is actually the underlying problem, rather than producing more and more guidelines, as Bartosz says, and more instruments. Like, can we actually tackle the underlying problem?
Thank you very much. Unfortunately, Bogdan can't join us because of this problem with electricity. It's and we have two questions in our chat. The first question to Bartosz: in the OECD guidelines 2023 review process, is it likely for a national contact point process to be improved?
Honestly, I don't know much details about the process, because I'm not taking part in that currently. That should be covered by some public consultation sometime, so then we can publicly read what's in the proposal. However, there's such a probability that also the proceeding before the NCPs will be reformed.
Okay, thank you. And also the question from Radka Ripov, actually about Central Asian region, and his question is about what do you think is the most important point to increase involvement of the Central Asian region to the process of green taxonomy, but we can ask more broader, actually, how to involve Central Asian region and Eastern European region to all these processes that were mentioned today. What could be drivers of such involvement, I would say?
So may I?
Yeah.
Nobody's answering. The crucial point of the EU regulations is that not only touching EU companies, they are designed to cover whole value of chain. Of course, there are right now big discussion. What does it mean, value of chain? There's a big discussion now. We're talking about only supply chain or value chain under due diligence directive. However, if these regulations are going to be introduced properly and covering as broad catalog of entities in the value chain as possible, then also the entities outside of the EU would be covered. So the idea is similar to what European Union should do in the area of climate change. The European Union should be the example and should also force their business partners to make a change. And also, it's of course our problem, I would say, or our task as Europeans to join this point of view, to join this this idea, because it will bring some cost for us. So that's the bad side of the situation, but there's no other choice to save this planet. So sorry.
Yeah, actually, it would be great, of course, if European Union would be taken as an example for this region, but we should be realistic again that the impact of China and Russian Federation is really huge in the Central Asia, especially. Maybe participants from Central Asia can share with us their thoughts about that. But yeah, I think that it's a challenge that European Union should realize as well, that when we are talking about future regulation in European Union in the region of Central Asia, we will receive answer in many cases that European Union is not does not have so big influence in the region as example China has or Russian Federation has. So it's a challenge. But maybe, yeah, Ekaterina?
Yeah, I can just add maybe a few things. Like, well, generally the problem with Eastern Europe, Central Asia, and I'm talking about the experience of Russia, where I'm coming from, is this lack of political will to enforce measures. There is weak governance, there is corruption, there is little general attention to business and human rights issues, and as a result, there is no really awareness and knowledge among the citizens as well. There is very little pressure from the citizens coming for the state to enforce anything. And generally, human rights issue is a very sensitive issue, right? It's a highly politicized, and there is not much interest or willingness from right holders themselves to push this agenda. There are attacks on human rights defenders, because if we see, for example, in Europe, in Western states, that lots of this debate is driven by civil society, by practitioners, by human rights defenders. But if we take, for example, Russia at the moment, there is almost no opportunity. There are still some brave people who are trying to do something, but there are all of those laws about foreign agents. There is a criminal prosecution. You can't say anything. You can't write anything. So, of course, there is a very limited opportunity to foster the same level of agenda as it is in Europe. And I think it should be understood about that, right? Like, what is this problem? That it's not that the right holders do not want to, or businesses do not want, just like limited opportunities as well. And I think that it's also one of the problems that lots of regulation is not drafted in human rights language as well. It is addressed in very different words. And I think this specifics, this feature is not always understood by the Western states, by the European Union. And I think it's equally applicable not only to Russia, but to China as well, whether it's, the human rights language has some sort of connotation of negative issues, almost like you don't want to get involved in human rights. But there are other could be possible debates. For example, ESG, sustainability, which is much more market driven. And maybe there is a way to introduce, like let's say if we're talking about climate change and green deal, etc. Maybe there are a way to introduce through those lines some pressure, some expectations.
Yeah, thank you very much. No, actually, my hope, my only hope for this region actually is civil society, to be honest. No, because I really hope that civil society will be a driver of the changes for this region. Anna, please.
No, I just wanted to add up. I think that also the chambers of commerce are very important players here, and I've been talking with a couple of chamber of commerce here, and generally they are interested, and they always come up with the question of who will finance this. So there are a couple of models that we look at now, that at least either the European Union or some other, maybe not UN agency, but donors will contribute or pay at least a cotization, so that at least we have the companies on the board and we start discussing, regardless on which regulation we touch upon. Either you want to introduce the UNGPs, because that's already a start here. Not a lot of companies know about the UNGPs, so at least to train them on that, they will need a financial assistance. And unless we have a concrete project by a European Union or another organization that will have the companies on board, I think it will be too positive or rosy to expect that they will divide part of their budget to be trained in the UNGPs. And we're not speaking about a lot of money. We're speaking just one sum. But again, it is difficult to convince. So I agree, NGOs can be involved, and there are a couple of NGOs that work in this line. It's just that I'm still shocked that by 2016, when I started working on this issue here, I haven't seen any NGO having a concrete project with businesses on these issues beyond organizing conferences and beyond some promotion of a guideline or a publication, but on a substantive level, there is not a lot of development. Thank you.
Yeah, okay, thank you. And we have one more question from the chat. Do you think there will be an evolution of the duty of care concept leading to parent company liability in jurisprudence and eventually in hard law, as it happened with human rights due diligence? I think that it's a question for Ekaterina.
Thank you. Yes, I do think that we'll see more expansion and more clarification, because there are already attempts. Well, first of all, I must say that the courts, few courts like English courts, Dutch courts, Canadian courts, they have really taken a few very important steps over the last even 5 years to expand and to clarify the scope of duty of care. And where we are now is very different from where we've been 5 or 10 years ago. So I think we'll see more clarification, and there are attempts to expand it to supply chains. There are attempts to argue a novel duty of care in relation to climate change. So I'm sure that we'll see more of those issues. And yeah, ultimately, you know, we already have French duty of vigilance law, which effectively introduces as a binding law this duty of care. So hopefully there are certainly, so duty of care and human rights due diligence are not necessarily the same concepts, not the same, but there are certainly few correlations and few similar aspects. So I think any developments at the legislative level on human rights due diligence also impact on how duty of care will be developed in jurisprudence and in the courts.
Yes, thank you. And Bartosz, yeah, you would like to add?
To this question, no, I fully agree with Katerina, so
Okay.
no need for that.
As an expert of civil liability, yeah. Okay, and my last question, because you know that New Year is coming soon, you know. So yeah, what is your BHR plan for next year, Ekaterina?
Well, happy to start. So I'm actually, I've told earlier that we finished last month our big project on civil liability. And at the moment, I'm at the start of the new 3-year project, which will examine climate change litigation against corporations. There will be a 3-year study, and I'm looking forward to looking at the patterns that already exist in judicial instances, but I'm also looking at non-judicial instances, because what I've noticed, there are lots of NCP cases under OECD guidelines. So what Bartosz was talking today about is very interesting to me, because I'm looking to study a bit more how OECD guidelines can apply in these cases. So hopefully next year, a few blogs, maybe an article will come up.
Wow, super interesting. Anna, share with us your plans.
Yeah, it's a little bit unpredictable. Our profession is very it depends on the cases, but I'm seeing a trend in uncovered slabs litigation. So there are a couple of cases that are brought by businesses against human rights defenders, and I have been involved or approached by a couple of NGOs whether I want to take up these cases. So I think that my ambition will be to unreveal that behind these defamation cases, you call it a defamation, there's a slab case, and there is no lawn slab. So I think we should really kind of try to advocate. I'm not a lawyer, but I guess kind of wake up the NGO sector that they should advocate for an adoption of a slab, because it's such a small country, but still there are some strategic investors here who are trying to kind of not scare, but prevent human, especially in the field of environmental protection. Some small NGOs, when they voice their concerns about the activities of the businesses, and here we have a litigation against them, and that drains them. It's really a problem here. So I think that I see myself in the courtrooms. If you ask me, at least now, but we don't know what will happen. So yeah. Thank you.
Thank you, Anna. Bartosz, what about you?
So we will continue what we are doing currently. So monitoring of new ESG regulation and engagement in the legislative processes connected with that on the European and national level, and also will to some extent engage in monitoring how the taxonomy is really working. So that's the next year, the first year of reporting this minimum safeguards issues. So we would like to see if companies are saying truth and how they are doing that, because we've got some very bad experience from previous years connected with reporting, especially climate issues and also human rights issues. So that's something that we'll read carefully next year.
Actually, yeah, opportunity to do what you do is a big privilege in today's world. So yeah, it's great. Yeah, so thank you very much. It was really very interesting, very inspiring. Thank you to all our speakers and to all our participants and to our interpreters and to our organizers and to Beata especially. Thank you very much.
So let me just join Olena and thank everybody and Olena herself for moderating the session and to everybody for participating in it. Many thanks as well for all the questions, and join us on the 6th of December when we'll be talking during the last webinar on children in the context of business. So see you soon. Thank you.
Thank you very much. Thank you.